Developing now, voice experts are testifying about what could be a critical piece of evidence in the George Zimmerman trial in Florida. The judge is expected to rule by the end of the day whether jurors will hear testimony about whose voice analysts believe was screaming on a 911 call just seconds before Zimmerman shot and killed 17-year-old Trayvon Martin last year.
I think they're yelling help, but I don't know. Just send someone quick. Say stop.
Okay. Does he look hurt to you?
I can't see him. I don't want to go out there. I don't know what's going on. So.
George Zimmerman has pleaded not guilty to the shooting death of Trayvon Martin. He claims self-defense, and we'd like to disclose that Mr. Zimmerman has sued NBC Universal for defamation, and the company has strongly denied his allegations. But joining the conversation right now, attorney Paul Henderson. No involvement in the case, Mr. Henderson has, but he's the deputy chief of staff for the Public Safety Office in San Francisco, and MSNBC.com's Tremaine Lee, who has been covering this trial. Gentlemen, it's good to have you here. And Tremaine, I want to start with you because give us a sense of what's happening. We've got these several different analyses of who's yelling on that 911 tape. Some say Trayvon Martin, others say George Zimmerman. The state witness who testified so far today, a person named Tom Owen, who has given an analysis for our own Politics Nation with Al Sharpton, says it's common for that to happen, this sort of muddying of the waters. Take a listen.
Mr. Owen, as far as the conclusions you reached, is it uncommon in your field for scientists to disagree as to their opinions of what evidence may show, even if they apply, generally speaking, the same types of methodologies?
Yes, they do disagree.
All right, so how do you think this is going to impact the judge? Because basically experts are trying to be discredited as experts when it comes to voice analysis that makes them worthless in the court of law.
This is clearly one of the great mysteries of the case. There's so much that we do know, but this is one of those elements that we don't know. Yesterday we had a FBI technician say that, you know, it's just clearly impossible to glean enough from that short amount of time, and the voice recognition is so muddy in terms of scientifically that it'd be hard to pull anything off. So the judge has to decide whether that bar that the FBI uses is the same bar that she'll use during this trial.
All right, so Paul, what happens to the case if the 911 case is not admissible?
Well, yeah, I think it's likely that you'll still hear the audio information. So you'll still hear the tape that we've all heard, and that's likely to be admitted. The standard that the court is using to evaluate whether or not the experts are going to be allowed to testify and whether or not their information will come in, the court uses a four-pronged test. And so what the court evaluates is whether or not the information and testimony would be relevant. And then they evaluate whether or not that information is necessary. So would what the experts have to say, would it help a trier of fact come to a conclusion? And then also, are there any exclusionary rulings in regard to that expert? And then the expert's qualifications. So the moving party has to lay the foundation and the qualifications as to whether or not this expert and what their opinion is going to be would be relevant to this case. And so that's the argument that we're hearing back and forth.
And what it's going to boil down to, Paul, is basically what you're saying, that most likely that this tape will be heard. The jury will have an opportunity to hear it. They just might not have an opportunity to hear analysis expert testimony about it.
Exactly. And so I think that's what's likely to happen. There's going to be a lot more fighting because no one wants to give up their experts, but the judge is in a situation where the judge has to determine whether or not hearing back and forth from these experts, which is common in big cases to have experts on both sides, whether or not that expert testimony in and of itself is going to be necessary, and if it would help that trier of facts and this jury that we haven't even picked yet to make a determination about what they're listening to on the audio tape.
All right, so Tremaine, there are also several defense motions that are under consideration, including whether to ban certain words like vigilante, whether to ban clothing featuring Martin's picture or support for him, and whether to extend Zimmerman's curfew so that he can travel to meet with lawyers. As a reporter who's been covering this case from the very beginning, the defense team has been very sensitive about how Mr. Zimmerman is portrayed in the public.
Of course.
And that certainly has to be a big concern moving forward.
It's definitely a concern, but this speaks to the tone that this case has kind of been embroiled in from the very beginning. This tit for tat, this war over characterizing the suspect, Mr. Zimmerman, and also the victim, Trayvon Martin. And so much of the way they've characterized this will paint either one as the aggressor or not. And so it's not unheard of for a defense attorney to try to have certain evidence withheld, but T-shirts, certain phrases, vigilante, self-appointed, you know, volunteer security guard, those kind of things, that's a little different.
MSNBC's Tremaine Lee, great to see you. Also, Prosecutor Paul Henderson, thanks for joining the conversation. Tremaine, I know we're going to be talking a lot more about this as you cover the trial. Still ahead,
Thanks
though,
for
on
having me.
today's show, Anthony Weiner's political comeback. He is hot on Christine